All right. I mess this up every time. You'd think we'd know by now.
So at the bottom, there might be a little, it looks like an open book, little icon. You can also go,
Okay, you're seeing the wrong one, right?
yes, so
Okay.
display settings, exactly.
All
Awesome.
right, that works. Gotta see where I'm looking. Thank you, Mitra. So today I thought it might be interesting to talk with everybody about testifying in court and depositions, because very often, whether we want to or not, we find ourselves pulled into the legal system, even just in our general clinical practice. So I often get pulled into the legal system knowingly, being involved in forensic evaluations. There's always the possibility to testify about the reports that we're writing. And we sort of get used to all the testimony that we're doing. But I know as a clinician, that's a very different scenario and feels very uncomfortable and very scary. So I thought today I would talk about the basics of criminal and civil courts, just so that we kind of have the same language that we're discussing today. Talk a little bit about the process of testimony. So what would it look like? What would be the steps and the stages that you would go through? The different types of witnesses that exist, and a little bit about subpoenas. And my goal is to focus this mostly on a situation where you've been pulled into court due to a clinical role that you have. So maybe you're seeing a patient for therapy services or treatment, and they're involved in some sort of legal proceeding. So you're being pulled into court, not because you're an expert in forensic psychology or psychiatry, but really pulled into court because of the clinical work that you're doing. Has anybody on here ever testified?
I've testified multiple times with my former job. I did in-home services for Safe at Home. So I was constantly in court testifying.
And Jocelyn, that would have been in like a fact witness role, right? Because you were testifying about your observations and what you were seeing in the home?
Yes, as a service provider.
Awesome, wonderful. Well, please give some anecdotes, kind of step in and ask any questions or provide any thoughts you have on this process. Aaron?
I've testified a few times. Fortunately, they were all over, a telelink, and so I was never actually in person in the courtroom. And the one time that I was subpoenaed to be in the courtroom, it was actually canceled at the last minute, so that was kind of nice.
Yeah, it's kind of interesting now that since COVID, we do a lot of our testifying over video. Even the depositions that I've always given have been over telehealth. And so that's a kind of a whole different world of testifying, because it's easy to get distracted when you're sitting in your office and your computer's, email is lighting up and you're still in court. It's very different than kind of walking into the courtroom. So Aaron, any anecdotes you have? I know you've been around this world of testimony for a very long time. All right, so let's just give a brief overview about the court system. I know many of you are not kind of inundated in the court system as I am on a day-to-day basis. But we have, for purposes of today's discussion, we're going to divide everything into kind of a criminal court and a civil court. When we talk about criminal court, this is where we'll talk about testimony at a trial or a hearing. And so a criminal case, think of these as somebody who breaks the law. This is the government charging an individual because they broke the law. This could be trespassing, as kind of more of a minor offense, all the way up to first-degree murder. The defendant in a criminal case is the person who they believe broke the law. They are presumed innocent until proven guilty, as we've all heard in crime shows on TV. And the goal is that they have to be found guilty to the extent of beyond a reasonable doubt, which means that we're like 95% sure they're the person that did this crime. In criminal cases, you have what's called a district attorney or the state's attorney. That's usually the prosecuting attorney. So they're the one who is saying, I'm representing the state of West Virginia, and Mr. Doe, you broke a law, and you committed a crime. On the other side, the defendant has a lawyer. These can be public defenders, which means the person is unable to pay for their own attorney, so one's provided to them. Or if they have the means to do so, a private attorney arguing that they are not guilty or that they should not be found guilty on these charges. So that's criminal law. You could find yourself involved in criminal cases, although I think sometimes civil, even family law kind of may be the realm that you may find yourself more likely to be involved in the court. With civil cases, we're looking at, rather than the government versus a person that could result in jail and incarceration time, we're looking at two people or two entities who are fighting each other to kind of fix a harm that the plaintiff believes that was caused to them. And so this is two people or two entities kind of arguing back and forth, and the ultimate result is money or money for damages, but it will not result in prison or jail time. So criminal court, we broke a law, can result in prison or jail time. Civil law, we're looking at money to fix damages that the plaintiff believes the defendant caused them. So in this case, a plaintiff is the person bringing forth the civil suit. A civil suit, when we say like somebody sued me, you're the defendant in that case. So the plaintiff is a person who is bringing the lawsuit forward to say that the defendant harmed them in some way by an action that they took or an action they didn't take and should have. Oftentimes in forensic psychology and psychiatry, we're looking at this as personal injury law. So that means that they have been injured by a party. They're trying to sue them for help with medical bills or therapy, depending on what the emotional harm was. In civil cases, the defendant is presumed innocent, similar to criminal cases, but there's a lower standard because we're not looking at putting somebody in prison where we have taken away their civil liberty. Instead, we are looking at it by a preponderance of the evidence, which kind of in layman's terms means we're about 50.1% sure that the defendant harmed the plaintiff. They talk about not having formal titles in these cases. Attorneys that do civil law tend to just be who they're hired to represent. I'm representing the plaintiff's case, the plaintiffs in this case, or I'm representing the defendant in this case. And there are other types of civil forensic evaluations we won't get into today, and some of those don't require an accusation of harm. But we're going to focus more on personal injury, which is where evaluators like myself can find themselves in depositions. Okay, examples of some of the cases we just talked about: criminal, broke a law, murder, robbery, assault, theft, bribery, neglect. Civil cases, issues like personal injury, could be psychological injury, could be a cognitive injury. Workers' compensation, meaning the person was injured while at work and their work is then required to pay for their treatment. Disability, fitness for duty, other capacities that we probably won't get into. We'll focus more on the personal injury today. Okay, so let's talk a little bit about the types of witnesses. There's kind of two main types of witnesses we're going to focus on today. There's the expert witness. So the expert witness is the person who is testifying using their expertise about a legal question at hand or a psycho-legal question at hand. So this is an example of this would be a forensic evaluator who evaluates somebody, interviews them, writes a report for the court that says, it's my understanding, it's my belief that this person has schizophrenia, and because of their schizophrenia, they're not able to go to court on their charges. They're incompetent. That would be an example of expert witness testimony. And because you are deemed an expert by the court in that case, which we'll talk about that voir dire process, you are able to give an opinion. You're able to give an opinion about a psycho-legal question. That is in contrast to fact witnesses. So fact witnesses, this could be a lot of different people in a criminal trial. A fact witness could be somebody, say it is a robbery. It could be a person who happened to be in the store when the store was robbed. So they would be a fact witness to say, when I was in the store, I saw this, I heard this, I felt this, I smelled this. So you're thinking about all of your senses, and we're really focused on what they observed, what happened in that moment, what they saw, what they heard, all their observations. What a fact witness cannot do is provide an opinion. They're not to say, I think it happened because of a fight between this mom and her son. Their job is solely to say, this is what I saw. And so a fact witness could be the person that observed, or an eyewitness that observed the crime. But a fact witness could also be a mental health provider. A mental health provider who said, I met with them on 5 occasions for therapy services. Each time they were on time, their behavior was normal, they reported their mood was good. Based on my observations and interview, you can kind of go so far as to say, I believe that their diagnosis is X, because that's part of our job as clinicians oftentimes is to provide a diagnosis. But we can't answer that legal question. We can't say, so it's my opinion that Mr. Smith is not competent to stand trial. As a fact witness, you're just saying, this is what I did. These are the services that I provided, and this is what I found in those services. So that's kind of, fact witness is what we're going to talk mostly about today, because I think that's where each of you here for this presentation may find yourself involved in the legal system. You could be involved as an expert. It could be a research expert. So for example, maybe you're an expert in a certain type of medication. And so you may be asked to testify. You didn't meet with a defendant, but you were asked to testify based on your expertise in psychopharmacology. Here is your belief about this medication, how it interacts in the body, what side effects it can have, how it interacts with other medications. And then you're more in that expert witness testimony. But you're sticking very much within your clinical expertise. And that's what the judge will qualify you on. And we'll talk about what that means in a minute. Any questions? So I wanted to stop here because in many of the cases where you would be like a lay witness, I guess most of these cases in general, there's going to be a subpoena. But if it's something about your clinical practice and you're being called into the court about, and it kind of comes out of the blue, you probably found out about it because of the subpoena. So in my world, I'm always expecting that it could be subpoenaed. For example, just a couple of days ago, I got a phone call and a message from the front desk and said, this private investigator is here from X county. They have documents for you. And so sometimes subpoenas can come from a process server. So if you've ever seen on TV shows where they put the documents in the person's hand, the person touches them and they say, you've been served. That's a process server. And that could be a subpoena for court. Usually it's not that dramatic. When they show up to the front doors of Chestnut Ridge, they just hand me the document. I'm like, oh yes, I was just on a phone call with the attorney about this case. I'm aware of this deposition that I need to go to. However, a subpoena in a case where you are the therapist or the treating provider feels a lot more uncomfortable than a situation where I'm an expert and I knew that it was coming. So my advice to everybody here when it comes to subpoenas is the first thing you should do is to consult with legal experts. If you're working for an agency or a company or a university, there will be a legal team that you can reach out to about subpoenas. And their job is to, one, determine if the subpoena is valid. So they make sure that this is an actual subpoena coming from an actual court and you're the person that's supposed to be responding to it. So this isn't somebody kind of making this up. They check the validity of the subpoena. They also make sure that you're able to testify on it, that, they can, the legal team can advise you on HIPAA and how to remain compliant with HIPAA while also fulfilling your duty under the subpoena. Our legal team here at WVU will help prep for a case in which you've been subpoenaed for. But the key thing to remember about a subpoena is that you have to respond to it and you have to appear. You cannot ignore it and pretend that it goes away. So while that seems like the easiest and best response, please don't ignore a subpoena. The only thing that a subpoena does is command you to appear. And subpoenas look different all over the place. I thought this was a pretty kind of basic one for you to get the idea of. It'll have the name of the case up in the top right corner. It'll say it was a criminal case. It'll say like State of West Virginia versus Mr. Smith with the numbers and the districts. This is State of Louisiana, which Louisiana's law gets a little funny. And this is the Office of Workers' Compensation. But it would have like the name of the case, and then it would say to, and this is where your name would be located. It says you are hereby commanded to appear at the office of, here's the location, date, telephone, time. Sometimes subpoenas will tell you must respond to this by checking yes, I can appear, no, I can't. I always contact the attorneys if I get a subpoena that I wasn't expecting and find out what they need from me. But just know that this is a legal document telling you have to appear at that location at that time. It doesn't necessarily mean that you're going to testify. It just means that you are told to be here. And then this following big empty box says that you are commanded to produce certain documentation. And so this is where it gets a little tricky as a treating provider. Then you're worried about HIPAA, what documents from my clinical notes can I give to the courts and what can't I, which is why getting that legal team involved, they can help you answer those questions. And then it says down here, this subpoena was ordered by, and it gives an attorney's name and information. This is helpful because this is who's calling you to testify. And you'll see when we get to the next slide that the person who calls you to testify determines who's going to ask you questions first in that testimony. So important to kind of look at who's ordering the testimony. You want to make sure that it's been signed, often signed by judges, although this person is signed by the Office of Workers' Compensation. Interestingly, this document that I pulled off is a fill in the blank document you can find online if you're writing your own subpoena. So you can imagine it's not hard for people to make subpoenas that may not be legitimate, which is why, again, we go through and consult with legal. Okay. So now we kind of have the backstory about testimony. I thought it would be helpful to look at kind of the flow, because I think one of the fears that a lot of people are very fearful of testifying in court, and it can be a very intimidating and stressful situation. But I think one option that's helpful is kind of understanding and demystifying kind of the flow of the process. Because when we know what's going on, we feel better prepared to handle it if it ever came to that. So this is the flow of testimony at hearings or trials. So you're thinking mostly criminal cases here. Some civil will be slightly different, but similar as well. But for the sake of this part of the presentation, think about criminal trials or criminal hearings. So the first thing that's going to happen, oftentimes, the judge will start the proceedings. He'll give an overview of what this case is and why everyone's here. He often asks both attorneys on both sides to, if they have any information that they want to share with the court. Sometimes they'll give a short summary of kind of what's happened, where they are, what the purpose of this hearing is. And then the judge will say something like, Attorney Smith, would you like to call your first witness? So you go back to that subpoena and you see the name of that attorney. And so say Mr. Smith was the attorney who called you to testify. So Mr. Smith will then say, I called Dr. Lillard to testify, which means I get up, I walk around the room, and I go and I stand by the witness chair, and I raise my right arm, and I swear to tell the truth, the whole truth, and nothing but the truth. That is not TV magic. That is truly what happens. I will tell you that on one occasion in West Virginia, not in a rural county even, I was asked to swear on the Bible. So they pull out a Bible and they said, do you swear to tell the truth, the whole truth, nothing but the truth? So help you God. I said yes, and I moved on. But I always tell that story to give everybody the thought in their mind to have an answer to that question. If you are an individual that does not believe in the Bible, does not believe in swearing to tell the truth on the Bible, then I would come to the testimony prepared to respond in that situation, because I was taken aback. Was not expecting to have to swear on a Bible. I've testified in the state of Georgia even and not had to swear on a Bible like I did here. But the first thing you're going to do, so my recommendation is if it's in person and you're in a courtroom, you're going to come in, sit down, and you're waiting for everything to begin. My task is always, the first thing I do is figure out the most direct path from where I'm sitting to where I need to go as the witness stand, because every courtroom is different. They're all everything's moved around differently in every courtroom you go into. And so my first job as I sit down is to figure out what is the direct path, so I don't look silly as I'm trying to figure it out when everybody's watching. By my direct path, stay standing until I take the oath, and then the judge will usually say, please take a seat. And so the first part, and this is if you're an expert, although I think they would do it even if you were a mental health provider. The next part is what we call voir dire, a very fancy Latin term. And I'm going to skip to the next page where we can talk about that. We'll come back to that slide. So the first step when qualifying somebody as an expert to testify is the court has to determine, are you an expert? So the interesting thing about court is that there's not some special document that says, Dr. Lillard is an expert. Every time I walk into a courtroom, the judge that is presiding over that case gets to decide, is Dr. Lillard an expert or is she not an expert? At this point, usually is not a big question mark, but it could be in a legal case. So every time you go into court, that judge gets to determine if you are an expert. And they do that based on the person having the knowledge, education, training, and experience in that specific area of expertise. So the attorney that called me to testify will ask me questions like, Dr. Lillard, can you explain your educational training for the court? And I say where I went to college, I got my master's, where I got my PhD, where I did internship and postdoc, and where I'm employed currently. They'll then, they may ask more about work history or roles within your workplace. They may ask your experience. How many competency to stand trial evaluations have you conducted, Dr. Lillard? They may say, how many publications do you have about this presenting problem, say schizophrenia? What training do you have specific to evaluating people with schizophrenia? Have you ever been qualified as an expert before in West Virginia courts? And so kind of all of those questions. And oftentimes that, have you ever been qualified as an expert in West Virginia courts is the first question. And when you say yes, they say, I move to qualify Dr. Lillard as an expert. And the judge takes it. Now, even recently, I had the attorney, not on the side that I was testifying for, tried to criticize my credentials to speak to certain issues in the case. And he was really grilling me on my qualifications. And at some point, the judge looked at him and he said, we are not questioning Dr. Lillard's credentials. She's qualified as an expert, and he kind of stopped the conversation. But I think those are pretty rare, especially after the first time of being qualified to testify. But just know that every judge in every hearing gets to decide, are you an expert? And they qualify you And so the attorney will say, I move to qualify Dr. Lillard as an expert in forensic psychology, or an expert in forensic evaluations, or an expert in forensic psychiatry, or an expert in the diagnosis, treatment, and assessment of schizophrenia. So they can decide what you're qualified in. And that means what can you speak to and what can you give opinions of, because you can only give opinions over those areas in which you're qualified as an expert. Oftentimes they just use forensic psychology and it kind of covers everything I need to do. Okay, so the CV, I think I went through all of this. They may focus on important parts of your CV, populations. Numbers are good if you have them. If you can say, I've conducted 300 competency evaluations, that's helpful to say. You know, testimony, a lot of what we talk about today is oftentimes I testify in front of a judge and not a jury. But when you're testifying in front of a jury, you also have to be kind of aware of, you want to come across as an expert and as a professional who understands the field in which they're testifying, but you don't want to come across as narcissistic or condescending. And so one advice is not to always over rely on titles. You want to kind of make sure that you're not off-put, you're not kind of frustrating the jury. And keep the answers kind of short and sweet. Because this is often your first impression to the trier of fact. The trier of fact is the person making the decisions, either a judge or a jury. Oftentimes judge. Okay, so we've gotten through the voir dire process. You're either qualified as an expert or you're qualified to testify. You've just kind of explained who you are and why you're involved in this case. The next portion of testimony is the direct examination. This goes back to that attorney that's on the subpoena. The attorney who called you to testify will be giving the direct examination. Direct examination is kind of the easier of the two parts of testimony. This is when the attorney who's calling you wants to ask you questions about the product, because your opinion in your product fits what they're trying to ask questions about. So you may have already met with this attorney, talked to them about the case. They may have given you some of the questions they're going to ask. So you can often feel pretty prepared for direct examination. They're going to focus on and highlight the strengths of your evaluation and how your evaluation kind of helps the opinion or decision that they want to make in that courtroom. These are going to be open-ended questions. These are things like, Dr. Lillard, what was your opinion about diagnosis of Mr. Smith? And then I can say, well, I diagnosed Mr. Smith with schizophrenia, and I can talk about all the symptoms of schizophrenia. And this is kind of your place to kind of show your expertise and show your kind of teaching abilities to the court of, this is what I did, this is why I did it, and kind of lay it all out for them. That's direct examination. The next step, so when that attorney's finished, he'll say, Your Honor, I have no further questions. That attorney sits down. The other attorney in the courtroom will then stand up, and that begins cross-examination. This is the more stressful and difficult part of testifying because you don't know what they're going to ask. You don't prep with the cross-examining attorney because these are not the people who called you. These people likely don't agree with your opinion or that your opinion doesn't help their view of the case. So they may have had other experts that help them prepare, maybe read the report and give some clues as to areas of weakness in the previous evaluation. Their goal is to focus on highlighting either weaknesses of your work, whether they're real or they're imagined. Attorneys are great at just like twisting things just a little bit to get their point and their opinion across. And so they're going to highlight, they may highlight that you're not credible of an evaluator. They may just be trying to make the point that you got the diagnosis wrong or you got the ultimate opinion wrong. And their questions are not going to be open-ended. They're going to give you closed-ended questions. The cross-examining attorney's questions are probably going to be yes or no questions. Dr. Lillard, did you evaluate Mr. Smith? Yes. Dr. Lillard, did you do any testing of malingering with Mr. Smith? No, I didn't. And they're trying to keep your answers short to yes or no. And as the evaluator, you're an expert, you're trying to get little bits across. I did not evaluate malingering. However, I evaluated other response styles in these measures. Or I did not evaluate malingering because my collateral interviews had enough information to determine that he was appropriately responding to my questions. And so you're trying to get little bits of pieces in, but know that cross-examining attorneys are trying to pressure you to be faster and answer only yes or no. And so this can be kind of, like I said, that stressful part. I'm going to go back a few slides. So when the cross-examination is finished, the attorney will say, Your Honor, I have no further questions for this witness. They sit down. The judge may then ask you questions if they choose to, but most often the judge will say to the first attorney, would you like to ask any questions on redirect? This is the chance for the first attorney to clarify anything that maybe got misconstrued on cross-examination. They can only ask questions about things you've already testified about on either direct or cross-examination. Once they're finished, the other side gets a chance to recross, and they get to ask any more questions about what you just answered in the redirect. And so it kind of narrows down, but they can keep going back and forth if the attorneys really want to. Oftentimes I've found I want attorneys to redirect examine me because I want to clarify something, and they don't ever think to redirect, and then I just have to kind of sit there and not answer. Questions on the flow of testimony? Okay. One last area for us. Is this showing up on yours? I'm sorry. I'm not paying attention to my little box there. The other area where mental health providers may end up testifying is in what we call a deposition. I find depositions a lot more stressful than testifying in court. If I'm testifying in court and an attorney asks maybe an irrelevant question or an inappropriate question, or they're just kind of being mean to me, which doesn't happen all that often, the other attorney can object, and the judge rules on whether that objection stands or doesn't stand. And if the objection stands, then I don't have to answer that question that is irrelevant or maybe just the not kind question. However, depositions are a bit different. So the purpose of a deposition, this is in civil cases, the purpose is to kind of feel out this expert. And so this is usually done by the attorney who has not called you to be their expert. So say the defense called you as an expert in your area. This would be the plaintiff's attorneys that are providing, that are asking the questions in a deposition. I say it's a feeling out process because what happens is a deposition is you give your testimony under oath with a court reporter. You are then given a transcript of your deposition. If that case goes to trial in that civil suit, you will be brought onto the stand to testify, and they have your words on paper under oath already. And that attorney will try to either trip you up or see if you're going to change your story. And so you not only have to kind of testify in this deposition, but you've got to remember what you talked about and how you opined on things so that you're giving consistent testimony the second time. The other reason I find depositions to be more challenging, so depositions don't happen in the courtroom. They're either going to happen in an office. So sometimes they'll come to Chestnut Ridge and we'll set up in our library and do a deposition there. I have a deposition next week and it's in some random office in Morgantown. And everybody's going to come there for the deposition. Or what has often happened since COVID is that the depositions are taken via tele. And so you just sit in your office and answer the questions over the video. They are under oath. there is a court reporter there. And so they're typing everything that you're saying, or they're dictating it into a machine, everything that you're saying, to keep a record of the deposition. And the deposition is just cross-examination. You're not going to have those easy, direct examination questions. You don't have a lot of room to kind of elaborate and explain. You are being asked questions by the people who are working on the other side of who you've been working with, and usually have an opinion that's different than the opinion that you have in that case, which makes it challenging. The other part about depositions that can be stressful is that you have to answer every question. For example, if the attorney asks a off-the-wall question, say this is a child custody case, the attorney could look at me and say, Dr. Lillard, have you ever been divorced? Are you married? Do you have children? And the other attorney can object and say, irrelevant, like, why are you badgering the witness? But in a deposition, you still have to answer the question. So if they ask really personal questions, I have to give that answer. Yes, I've been divorced, or no, I've never been married, or yes, I have children. And then what happens is that in the trial, the judge will look at all those objections and decide what gets thrown out and what gets kept. But because there's no judge or trier of fact in a deposition, you have to answer everything. So that is depositions in a nutshell. And I added a couple of sources of books that we find really helpful when it comes to testifying, if people are interested. All right, what questions do we have now?
Thank you so much, Dr. Lillard. So much great information there. I feel like this PowerPoint is one I personally would keep on hand that I could refer back to if I had to be involved in testifying and all of that. But thank you so much. But yeah, anyone with questions, comments, feel free to unmute and chime in. You're also welcome to chat in and I can read the question out loud.
Thank you. I was like, I'm trying to unshare here.
No, you're
Thank
good.
you.
Of course. Any questions or comments from the group?
Jocelyn, any war stories from testifying?
Yeah, I definitely have some war stories for sure. Especially when it comes to CPS cases, those were always not the best time. And it really depends on the judge. You know, when you were saying that there are times where attorneys will constantly kind of badger you about your credibility. I've also had a judge that has done the same thing. And, you know, the best advice I was given when I was preparing was that you have the amount of time that you need to answer a question. So don't feel like you have to give an immediate response. You can take a beat. And that was for me the most helpful because my anxiety would definitely raise. And, you know, it's intimidating when someone's asking you about your credibility, especially as a service provider. And you just want to say, I'm literally just trying to help them, you know? So I can say that I wish I would have had this session 6 years ago before I had to start testifying. But yeah, this was all fantastic information and definitely like would help somebody who's never been quote unquote in the hot seat before.
Yes, those are excellent points and things that I've forgotten, and they go along with Peyton's question in the chat here too. And that's especially on cross-examination, just remember that you can control the pace of the questions. And you can do that in a couple of ways. You can, when I get asked a question that I don't really know the answer to, I often ask, I'm sorry, can you repeat that for me? Which just gives me a chance to hear it a second time, even if it's just because I need a second in my head to formulate a response. And sometimes I just say, I need a minute to think about that. And that's okay. Like Jocelyn said, it's okay to have a moment of silence where you kind of bring your thoughts all together, organize them in your mind before you speak. Be sure to only answer the question that is being asked. You don't have to be helpful in testimony. Now, I'm not saying don't be antagonistic, don't be kind of mean to these attorneys, but if you are asked, do you have any children? My answer is yes. My answer isn't, I have X number of children, ages 7, 5, and 2. It's yes. Answer only the question that's been asked of you. Don't feel that you need to provide extra information, especially on cross-examination. And oftentimes attorneys, sometimes they'll just speak and there's no question. And I've also been known to just kind of sit and wait for a question, or say, I'm really sorry, I don't know what the question was. Or if they talked for a really long time, you could just say, could you repeat that for me? I got a little bit lost. All of that are chances for you to kind of take a deep breath and figure out how you're going to respond. It is perfectly acceptable to say, I don't know. Be okay saying, I don't know. We don't have the answers to everything, especially if they start asking hypotheticals, and I don't know is a perfectly acceptable answer. Peyton in the chat asked, are there any strategies for dealing with anxiety surrounding court, specifically in situations you're not able to prepare for? The best way that I have prepared for stressful testimony is that I've met with colleagues who are also in the same area, and I've had them review the document that I'm going to testify on, say my report, and I have them pretend that they're cross-examining me and what would they ask me. And so it's a way for me to kind of see these might be the questions. So finding a colleague that can be really helpful and maybe is really critical of reports. I have a colleague who's fantastic. She can think like a prosecutor. And I remember has been one of my worst testimonies ever. I had a big case. She reviewed the report. She provided me this list of things that they could cross-examine me on. I said, these questions are really hard. There's no way they're going to ask me that. They asked me every one of them, and it went as terrible as you imagine, because I was like, there's no way they're going to ask me all that. So I advise working with colleagues, or even that legal team, having them review the evaluation and say, hey, what types of questions might they ask me about in my testimony? As far as anxiety, I mean, take a deep breath, maybe have some water, either water bottle with you. Sometimes they'll have water up on the stand, so you can kind of take a drink of water. That gives you some more time to kind of breathe and prepare for an answer. Jocelyn said, having a supervisor or somebody from legal go with you as a support helped. That's true when you have a hard judge or a hard case, because then you can kind of look into the audience and see someone that's kind of had your back. So that is really helpful to be looking at a smiling face and not this attorney who's really intense. Yep, you can. Jocelyn also said that she would do homework and make a cheat sheet of answers to proposed questions to have with me. The thing to keep in mind with that, I also would do the same. Anything you bring onto the stand with you is available to be put into evidence. So don't bring the whole file and all of your notes onto the stand with you. Those stay in your purse or your bag at the seat. If you're the only one there and you have to bring your purse up with you, I often just kind of leave it on the bench in a corner. But if I felt like I had to bring my my bag with me, make sure it's sealed, either Velcroed or zipped. They can't make you take something out of your bag and put it into evidence. But if you have all of your notes on the table in front of you, they can put all of that into evidence. And so what I would do is I would do a one-page, I would type up one page on the case, and it would just have only information that was already provided in my report that they have, but it would put it on one page. My diagnosis, what medications is the person on, what are the dates that are involved in this case, because those are the things that I tend to forget. And so I would give myself, like Jocelyn said, a cheat sheet of just information that was already available to the court. And so if they said, can we put this into evidence? I would say, yes, that's fine. It's just my 1-page kind of summary. And that did make me, so Jocelyn, thank you for that reminder. That really was helpful when I used to do a quick cheat sheet. And just
Pauline, it's wonderful as always. I learn something every time you talk. I kind of have a question, and I've been subpoenaed a lot more in my new role than at any point in my prior life, which I find fascinating. But you know, one of the things that I think that you kind of highlighted, and I know sometimes you actually are the expert for the court, and you've been court ordered to do it, but my only experience, and I think probably most people have been, is that fact witness or something like that. And you know, one of the simple things that I just learned a long time ago that just really helps me is, what is my role, and making sure that I don't feel like it's winning or losing. Every courtroom I've ever been on, someone is fighting to win, and it doing whatever you can not to get into that mentality is truly one of the most helpful things that for me to do, because what I've learned, and although you want to be helpful, especially as a clinician, and that's our role, to be helpful, that is not how courts think. And I think the first few times, like, I watched a judge make a decision that felt catastrophic to me for that child, usually a child or someone, you know, I mean, and I would like cry. It was such the wrong thing medically. It was just really having to separate myself that, you know, they don't care medically. I mean, I mean, that's not their role. They're answering questions of a legal nature or of a process nature, and we don't have any control of that or any ability to do that. And you have to let that go. You have to just go be honest and state things, and you're not the one on trial. And you can't get emotionally invested in it. And I know that's really, and I think as providers, like for me, it's very hard not to be emotionally invested in things that you care about, and that's the hardest part. And so I don't know what other, I know you have way more experience with that, but that's my like problem every time, is I have to detach emotionally from it and just realize that this isn't medical. This isn't about winning or losing. It's just about stating the facts of my involvement, and that answer, I don't know. Or my favorite is, I was never in a position to answer that question. Right? I'm not capable of answering a hypothetical question that is beyond the scope of my skill. And I would say things like that because they don't understand either why you can't do that, and you just have to say no sometimes. And it's hard to say no too when you're a helper or you're trying to be a helping person. And so saying no and making it not emotional are the only things that ever got me through it. But I hate it. I absolutely hate it. If you like it, maybe one day we'll get there, but I really appreciate this, because I think it is really, really stressful and really anti what most of us in healthcare started our careers with. But I think, especially if you work in mental health or with kids and families, the chances of you not getting subpoenaed are probably slim.
Yeah, no, I think Dr. Schweiger made some really good points there. You do have to separate yourself from the case, which I'll be honest, I've never testified as the therapist or the provider of that person. I've been subpoenaed once in a case that I was more the like practitioner, and it was super stressful. Like, I'm used to doing this, and that was super stressful because it's a different role. It's not the role you walked into the case on. So it's much easier when I just do an evaluation and I can just stick to my report. It adds a whole nother level. But the other thing not to get invested in, and Jocelyn kind of brought this up, is that they may try to tear down your credibility, and you've got to find a way to answer the questions without getting defensive. And that's really hard when it feels like they're telling you you're not good enough, you're not smart enough, you're not X, Y, and Z enough to opine in this case. And you have to do your best not to get defensive. And I'll tell you, my really difficult testimony, I cried half the way home from Charleston because it just was really hard to separate. And I'll be honest, that's one case where I was very invested that I was correct in my opinion, and they went against me. And I think if I had left myself out of being invested in that opinion, I wouldn't have taken the testimony so hard. And so it's a lesson that we all kind of have to learn, but it would be really challenging not to feel invested in a case where you've worked with this family for months and months and months, and then the outcome isn't what you expected it to be.
Something that has helped me detach too, was just asking if after my testimony, if I could be dismissed instead of having to sit there the rest of the time. Because sometimes if I would go like first or second, I would give my testimony and then I'd have to sit there for the rest of the proceedings. That's when my anxiety would rise too. And they can always ask you to come back up to the stand. But if they dismiss you, you're dismissed. So then you don't have to go back up. And that's the little cheat that I learned.
Oh my
That
gosh,
is-
I love that. I
That
really
is so
I had
smart.
done that. That is excellent advice.
And I'm actually the opposite, Jocelyn. I always get really frustrated when they dismiss me because I just want to hear the rest of it because I'm curious. So it's kind
Not me. You say I'm dismissed. Bye.
But I think that goes back to understanding your role, right? Like,
Yep.
you know, I mean, like, I think if you are emotionally invested or you've already been challenged, like, I think that's an excellent way to separate yourself. But again, I can see if you're not, if you're the expert witness, even if you approach it differently. I mean, it's almost, it's like therapizing yourself and before you go into that court and how you're gonna go. But I love that, and I have a subpoena I got to deal with, so I'm gonna make sure I ask to be dismissed, Jocelyn.
Pull a Jocelyn.
That's wonderful. And then sometimes you get sequestered. I didn't even kind of go into this, but in the case that I testified in a couple months ago, they didn't want my testimony to get clouded by whoever testified before me. So they made me sit in the hallway until it was my turn to testify. Which in that case, I was frustrated because I really wanted to see the testimony of the other people in front of me. But that can also be, and that's just kind of frustrating because I literally sat in the hallway for 3 hours, playing on my phone. So, no other questions. Jocelyn, I really appreciate your thoughts and, you know, feedback and what it was like for you. I think that's really helpful to hear everybody's thoughts.
Yeah, it was really nice hearing everyone else's experiences and stuff. So thank you all for chiming in. Jocelyn says, good luck, everyone. Any other questions, comments? We have a few minutes left. Alrighty, well, as always, thank you so much, Dr. Lillard. Another great presentation from you. And like Dr. Swagger said, I always learn something anytime you present to us. So thank you, thank you. And I appreciate all of you as well for joining the session and chiming in. We always love hearing from you all as well. So we appreciate you all. Thank you, Elizabeth, for the reminders. So the next time we'll meet will be through the new iEcho platform. Again, if anyone has any questions before that next session, you can always email us. We're happy to do one-on-one Zooms. And if for any reason you come into any difficulty joining the session that day, don't worry, like we'll wait until everyone's on and everything. So we totally understand it'll be kind of a change. So
when I don't arrive, please message me. You're in the wrong place.
okay.
It's
Yeah.
wrong.
I will definitely message you if you enter some Zoom with no one in it. That's suspicious. But yeah.